Good morning, Michael. Thank you for taking the time to talk to us today.
Morning.
To begin with, could you start by introducing yourself and your role at QPS?
Yes, Michael Ede. I'm the superintendent here in the strategy group for the Domestic Family Violence and Vulnerable Persons Command. So I overview the strategic work on behalf of the Queensland Police Service addressing the areas of disabilities and elder abuse, mental health and domestic violence.
What work has happened within QPS to prepare the members to adapt and respond to this new legislation?
Okay, so when we talk about the new legislation, I'll focus on the criminal offence of coercive control, and I don't want to bore your listeners, but just a bit of background and history. We're talking about domestic violence as from a legislative platform in Queensland since 1989, but it was established on the old traditional and a more restricted perspective of what domestic family violence was, and that was your physical abuses, and the like. And I won't call them traditional. That was the perspective that existed at the time when that legislation was commenced. 2012, the Act was reformed, and it introduced the concept of coercive behaviours. So the element of coercion was introduced into the legislative framework back in 2012. So the concept was introduced. It was new, and it came out of studies, research, bodies of work that were being done to indicate that the domestic and family violence behaviours needed to expand because it was more than just the old school physical abuse. So it expanded its definition back then. The problem there is it takes a cultural shift for everyone working in the sector, and law enforcement agencies, government agencies, to pick up that the new concept of domestic violence behaviours. So over that time, from a Queensland Police Service perspective, what we were doing was doing our studies and engaging with professional bodies, external bodies, to uplift our education for our staff, and that commenced as far back as 2017, post the Not Now, Not Ever report, where we introduced training to officers, and we had two topics there that we were trying to refocus on, and that was mental health and domestic violence. So we went down the concept of what is trauma-informed practices in regards to domestic violence and mental health, which is not an isolated issue. It overworks, or it's intervening in domestic violence as well. But to get across the expanded definition of domestic violence behaviours, post that 2017 effort, we had online learning products about coercive control to understand the longitudinal aspect of it, that it's a invasive, manipulative approach across a period of time, and that it doesn't involve traditional offending practices. It's covert, it's behind the scenes, behind closed doors. So that's been what we've been trying to do over since at least 2017, if not 2012, when the legislation changed, was introduce the concept of coercive control to understand inside relationships the insidious nature of manipulation to influence the behaviours of another person who might be subverted by the behaviours of another person. So that those online products came through. Women's Safety Justice Task Force found its way to being published in 2021, and it introduced, from comparison from other jurisdictions and international responses, the need for the offence to value add to the behaviour of coercive control. And that came through the 2024 Amendment Act, the Criminal Law Coercive Control and Affirmative Consent amendment legislation that introduced the offence. But prior to that, the Queensland Police Service had come through a few inquests that were talking about the nature of our investigations, and that they were less than holistic, and they were missing points. So we did, as we mentioned in the round table, and I think Ria mentioned the question about our training. So 2022-2023 financial year, we introduced a 3-day holistic approach training for domestic violence. And one of its centre points was, again, addressing the concept of coercive control. And this will lead on to some of your other questions, I'd anticipate. And all that essentially meant was moving away from turning up and dealing with the incident that presented that at that particular junction when police have received a call for service, be it an assault or otherwise, but it's then one, immediately understanding that there's a relevant relationship involved, and then working back through the longitudinal nature of the relationship to see what else is going on. So that's what we mean by holistic. So that 3-day course did it. The next training financial year 23-24 was followed up by an extension of the domestic family violence holistic approach training. Both of these were face-to-face concepts. And then this year, the last 24-25 financial year, we had a 1-day face-to-face course for all officers, which was centering around coercive control and the offence. So it's not as simple as there was an offence introduced. There's been a longitudinal approach to educating, and there's still a long way to go. No one's denying that fact, because there's never, you can never write down enough on a piece of paper exactly what might be going on and how someone's behaving to control someone else. But it's having the eyes open to it so that it can be investigated, and then the criminal offence can apply.
Yes, I think that's really important context, that it's not a matter of one day there wasn't a coercive control offence and the next day there was. There was a lot of work that went up to understanding the nature of these relationships and the dynamics that are going on and unpacking that in different ways over the years. We've heard a lot from practitioners who are very concerned about the risks of misidentification, especially as they relate to Aboriginal and Torres Strait Islander people. Has there been any additional work or any additional support to your members to work in those communities, especially remote and discrete Aboriginal communities?
So broadly, all those training packages we mentioned all had components there of misidentification, and they were all addressing that 22A concept of making sure that we're no longer just unilaterally taking the version of one or the other, or accepting that there's domestic violence behaviours being perpetrated by both sides of the two parties. It's now having to delve into it to find out who is the person that's is truly being the recipient as a victim. So that's been through our training products, and that training products also has a cultural lens on it, broadly, because a police officer that's working on the Gold Coast today could well in a year or two be transferred to a more remote location. So that training was there for everyone, so that irrespective of where you're deployed, for whatever the circumstances might be, you have that basic understanding. And then through a number of other inquiries and task force outcomes, we've also had to relens our orientation for officers going to those locations, so that they have a contextual arrangement for the particular environment that they're now working in.
And I also understand that training contained information about understanding stereotypes around who the ideal victim is and who the perfect victim is. Can you talk about what training or what information has been provided to help unpack those ideas that often get in the way of identifying the person most in need of protection?
The simple answer is that we categorise them as a myth. So the learning approach was, as many movies or television shows you want to watch, where it's easy to idealise what a victim looks like, and everyone's seen those productions. It was attempting to find a means to deconstruct that myth or that perception, and as a result, our training products actually do just call it a myth. That was the category when we went to misidentification and victim identification. We started out with a number of, when you're doing research, you call them assumptions, as in their predisposed factual positions, called them myths, just straight out called them myths, and said, and police should know it more than anyone else, that the ideal situation never exists. You can be uptown in Ascot one day doing jobs, and you can be south side of the river and in Logan tomorrow, and the socioeconomics are essentially irrelevant. It's the concept of finding out through evidence, and this is where our strength lies. we're supposed to make our decisions on an evidence-based matrix, because our responses to any of these incidents will be either a protection order application or a criminal prosecution. And both of those have to be premised on evidence.
Let's turn to some of those actions now, because there was, with a tremendous stroke of luck and timing, some data published today, which revealed some of the stats that are coming through around a whole range of different criminal actions, but specifically around coercive control. So I've had a quick look at those figures. I haven't dived into them with any great depth. But what I can see there is that in the 2 months since the offence has come into effect, there were 42 victims of coercive control identified, and there were 8 recorded offenders in that same time period. So can you help us understand a little bit about the story behind those figures? What's that actually telling us?
Well, bluntly, not a lot, because we're still in formative stages. So 50 occurrences, when you if I put it in context, Magistrates Court Queensland can range over 400,000 charges per annum. So we're talking 50 occurrences, which may or may not result in a criminal prosecution. So it's a small data set, and here we're trying to monitor as well to look to see what that means. Some of the questions your audience may want to know about is things like our charging practices or our investigative practices. What it means at the moment, though, is for those 40 odd occurrences, 50 odd occurrences that have been reported, that means that we've got some wedge in that there might be a longer relationship involved, and the individual we've spoken to has been able to disclose to us that there's more than what's happened on the night. So if we took the hypothetical, this is the first time someone's engaged with police, and they've indicated, we've asked the simple question of what's happened tonight, and we've got some rudimentary information, and when we've asked the question about the relevant relationship, we've figured out that it's been going for X number of months or years, and we've asked the preliminary introductory question of, well, what else has been going on? And we've been provided with some information that suggests that there's a pattern of behaviour or a course of conduct, and the officers then picked up on that and entered the occurrence, which is in our language is essentially putting on the system to investigate the matter further to see if we can flesh it out.
So these are occurrences, not charges. Can you just step that out a little bit more, so that when this is just a recording of something that's been observed or heard or noted by one of the officers, it's not necessarily resulted in a charge?
No. So that just means that we've received a call for service, we've attended, we've done some preliminary investigations, and we have identified that certain offences may have occurred. So we put them on the system for the purpose of investigating them.
The other big thing that people are very concerned about or interested in is the collection of evidence. Can you talk about the ways that QPS are prioritising evidence, how they're identifying, what are they using to evidence these offences, these occurrences that they're noting?
Yep. So the concept of prioritising is more, it's more viewed in a chronological aspect. If we turn up at a location and there's, say, the victim, they might have friends or family around them, the perpetrator's no longer on scene, the prioritisation of evidence is attempting to communicate with anyone that was present that has seen things happening to obtain a version from them to determine whether or not there's an offence that has been committed. So the first step in any investigation is talking to the witness to obtain an understanding of what went on. So if it's prioritising, it'll be those people that we speak to, the victim and anyone else around, at the first point of contact to see what they can tell us. And then the investigation expands from that, and it's then following out those threads. So if that say there was a witness at the scene and they say, no, I was I was out in the backyard when whatever happened, but I know that person X was there was inside, but they're not present, and that's a follow-up for that individual as a potential witness. So the investigation will generally happen organically based on a logical path of following where the evidence leads us.
And what about the role that statements or reports from specialist services or notes from specialist services, what role might they play in building your investigation out?
So the first thing is that when we attend at just after a heightened situation, and this comes down to our investigative process in regards to interviewing people and obtaining versions, a particular victim may not be in the best frame of mind, still operating under fear or of retribution. And I'm not being discreditable to any witness or victim, but the circumstance of being tired, it's 2 o'clock in the morning, alcohol, drugs, mental health, whatever the circumstances might be, we might get a particular version or no version. But if that person then determines, and talking in context of a support service worker, someone walks into a centre the day after or days later, when they've had a think and they're concerned that things didn't go the right way or they didn't get their version out in a fulsome manner, and they've turned up looking for support or assistance, and then post that assistance they've determined, yes, I want to go back to police, or I haven't seen police yet, and they've determined, yes, I think I'll engage the police. The concept from the social worker is there that they can be involved from a preliminary witness stance, where the individuals disclose to them what went on. So they've said, 2 nights ago, I was strangled, I was in the car, or I was in the garage, it happened in this context, and the worker goes, fine, okay, gotcha. Have you spoken to police? Yes, they turned up, but I didn't tell them that at the time for whatever reason. Well, then what did police do? Well, they didn't take any action on the night. Or maybe we could re-engage with them and provide them a more fulsome explanation of what went on, or version of what went on. From the social worker's context there, the primary response we're looking for is the providing a stable platform for the victim to actually come forward and give us that information, which is that evidence we talked about before. Mm-hmm. That's what we need to engage to move a protection order application forward, or to do a criminal prosecution. If we don't have that information, and we have to proceed on evidence, then we can't move forward. So our first point of call is if they do come forward to an agency, and that they are prepared and in their own means, and their safety is all assured, that they want to engage with us, that they come to us with the set of facts, the version that we can then deal with. Whether they've told us something else the night of, or they didn't speak to us, or they couldn't give us much information, not a problem. That can always be contextualised. There's a reason that they didn't speak to us, be it fear of police, fear of retribution, all of those matters. And I'm probably leaning now into the Evidence Act was actually changed so that the concept of what constitutes domestic violence, the history, the social context, the influence, can all be explained now to a court. So if they had provided a lesser version to us, or not provided anything, or didn't want to cooperate because of fear, but they've come in later and given a version, and then told us more fulsome material, well, that's logically explained. So it's not a barrier.
Back to one point about the law, which is the way that it's not retrospective, and that it only applies to behaviours that have happened after the 26th of May. Can you talk a little bit about what that might mean for what your members can and can't do?
Yeah, it's not a black and white answer to it, but at any time in our statute that we introduce a new offence, it can only be charged going forward. If today they introduce an offence for touching your nose with your left hand, I can't prosecute you for having done that yesterday.
Mm-hmm.
I can only do it for going forward, and that's just a principle enshrined in law. So you can't be prosecuted for something you did in the past that wasn't an offence at that particular time. So that's the standard from the legislative standards. Fine, if that's an accepted rule, the concept there is that it's the coercive control, the course of conduct. Yes, there's got to be behaviours that exist post the 26th of May for us to prosecute, but that doesn't mean that the domestic violence behaviours that have occurred before the 26th of May aren't admissible or usable in that criminal prosecution. The Evidence Act clearly is indicating yes, they can.
That's really interesting. I don't know that
So,
that's as well understood as it could be. So that's really
no.
helpful to know.
So 20-year relationship, DV's been happening since day one, post 26th of May, as long as there's behaviours or the course of conduct exists post 26th of May, the Evidence Act indicates that we can still evidence the behaviour prior to that to highlight that there's a domestic relationship and there's domestic violence behaviours in it.
Going back to the victim survivors, you've talked a little bit about how important it is for you to have all the information that you possibly can have, to have all the different types of potentially, photos or statements and records and all that sort of thing to help the police build their case, to flesh out that investigation. So can you speak in a little bit more detail about the sorts of things that someone should bring with them if they are coming into a police station to say, I believe I am the victim of coercive control and I want you to do something about it? What should they bring with them? What should they do?
Yep. So bring themselves in the first instance, and from the agency perspective, they're not. No one's trying to plant on them the concept of understanding how an investigation works. If an individual discloses that domestic violence behaviours are occurring and how they occurred, that's fine. The concept is having the victim in a stable enough position where they've managed to think through what's occurred and they want to engage with police. So they've got it's never as theoretically clean as to say, we'll get it all right in the first instance. No victim can, and even our interviewing techniques, particularly for a witness, has the concept of we'll just sit the individual down and we have to essentially say, so what happened on the day that we were involved, or the day that's got you to the point where you want to choose to engage with police? What happened then? And then what we're going to get from them is say, so explain to us what's occurred in the history of your relationship. And we'll try to, and from our perspective, what we do is we get the witness to just do a narrative, explain the background of the relationship, what's occurred over time, and then we'll start. And probing sounds a bit like there's an alien, but no, it's just probing questions to say, so if the witness, and the witness is not required to understand the legal framework, it's for us to question of them. And when I say question, not question their veracity, but provide questions to them to say, have you got kids? Have you got pets? Where do you live? Who else is involved in this relationship? So that we can start working through the factors. And I use pets as an easy example. Yes, I have a pet. Okay. How long have you had the pet? Oh, it's 10 years old. Okay. How does the perpetrator behave with the pet? And we'll try to put questions that focus the witness to go to things that are, and we'll explore what's important to the interviewee, the victim, but then we'll have to ask questions and explore what's important to the elements of an offence. And that probably doesn't mean a lot to yourself or your viewers, but the elements of the constituent parts of a charge, and they'll be, what time did it happen? What date did it happen? Where did it happen? If it was an assault, how did the assault occur? Was it a closed fist? Where did the strike land? And what type of harm was involved? Did they break something? Did they bruise something? Or was it the assault, the strike made contact, but it didn't leave a lasting injury? So we'll ask of those types of questions because they're elements of a particular offence. So it's getting the narrative, we'll come back and probe and question to find out and flesh out materials that the interviewees indicated are important, and then we'll come back and try to find the details that are relevant to a criminal prosecution out of that version. And it might, if there's a longitudinal relationship, we might be talking 20, 30 incidents that their memory can best bring out of their episodic recall, i.e. they can remember a day when they were assaulted, they can remember the day that he punched a hole in the wall. They can remember the day, and this is what I'll answer one of your other questions. They sent me the text message. So that's then the concept of, we'll ask, do you mind if we then have a look at your phone? Have you got a copy of that text message? So that's documentary evidence that we'll take. So we'll explore that and ask the question. So what we need is the victim just to come in stable and prepared to have I don't want to call it impersonal, but an individual they may never have met before, asking them a lot of questions about their relationship. And that's the thing that we're looking for, that they're better prepared to come in knowing that this isn't going to be an enjoyable experience, because we're going to ask them questions about their relationship and their victimology.
Yes, and I think, when you're working with victim survivors, you've got your set of goals that you have in order to complete your work and do what you need to do to get a successful outcome. And victim survivors will often come with their own set of goals, and they might be, I just want you to take me seriously. I want you to know how important this is. I want you to know that I feel unsafe, or I'm worried about my kids. And they might be focused on a particular aspect of what's going on, and they might be focused on telling that part. And to have questions coming back which are, do you have any pets, might not seem logical from that perspective of that victim survivor. So do you do any work to say, hey, look, I'm going to ask a lot of questions. They might not seem like they're relevant or useful, but trust me, there's a plan, there's a process, there's a reason behind this. Do you do any of that work in that conversation with that victim survivor when they come in?
So the interviewing any witness, it's the concept of the first, and not trying to oversimplify it, but the first stage is tell us what you want to tell us. And as you indicated, they'll have their own focus, what's important to them as an interviewee, and they'll regurgitate a lot of information. Our job is then to listen for what is important for what we can do, protection order application or a criminal prosecution. And this is where it's listening carefully to the narrative that we're receiving, then go back and clarify and probe on stuff that they've raised. So going through their material, because that's still important to them. So we get the base material there. And some of our investigators, particularly our detectives who are trained, specifically trained in this, and for example, the sexual violence investigators, they're very experienced in this, and these are lots of the training that they get that we're trying to push down right down to our standard operational officer general duties, is to understand that when you're the individual that you're interviewing may not understand why you're asking such a probing question, and the most easiest example and damaging type of question that some people don't, that a lot of people don't understand in victims, is sexual assault matters of what you were wearing. No one's disagreeing that it doesn't matter. You're entitled to express yourself in whatever means and however you wear it. But the concept there is making sure that when we're asking that question, we should also be giving an explanation as to why we're asking it. And the concept is not because you've drawn attention to yourself and made yourself a victim. That's not the purpose of it. It's as simple matters of, well, now I know what you're wearing on the night. If I'm going looking for CCTV, I can identify you, even though it might be grainy footage and I never recognize your face, but I can start to map certain things. Or if I'm potentially interviewing other witnesses are saying there was a victim and they were dressed in a green dress on the night, wearing a purple hat. Do you remember anyone matching that appearance? So these are facts of evidence that we can draw on to progress our investigation. But if asked without context, it has the unenviable position of maybe putting the victim in some sort of mindset that we're asking the question because they were the ones that did this themselves, and that's not the case. Yep.
Yeah, that context is really, really important. One of the things that we've heard a lot from practitioners is that they're very motivated to understand ways that the working relationships between services and QPS can be improved and enhanced and streamlined so that, you know, victim survivors get the best response from all points in the system as they can.
Those relationships, you're right, they're completely important, and particularly, I'd probably harp it back to misidentification. If we've engaged with someone and only gotten a small piece of the puzzle, because, and I keep referring back to 2 o'clock in the morning, when things are all heightened, nothing is settled, everyone's backed into their corners and they're fearful about coming out for whatever reason. Yeah, we might be only getting a small piece of the puzzle. If they've come to an agency, it's the information sharing, it's the cooperation, and probably the first thing to premise that with is again reinforcing that our role is the protection order application or the criminal prosecution. Outside of that, we don't have the resources or any permit or authority to be doing much of anything else. So when they're coming to us, it's knowing that these are the levers that are being pulled.
Yeah.
So the cooperation there is if they're seeing a victim and that victim is indicating they need that their safety approach requires a protection order that's appropriate, and they're going to come forward, then that's what we're asking of the agency. And on that side of the fence is bring them forward, knowing that this is not going to be a simple route. We have to explore things because we have to meet certain evidentiary standards, and then from our connectivity back, we've got to listen to the information that's being presented to us, that something happened, we didn't get it right, or there's more to be shared. Here comes this person, and we have to be receptive to that engagement. It's tried to say, but that's the communication structure. Someone wants to communicate something, the individual on the other side's got to be receptive to that information.
Is there anything that you think that I should have asked that we haven't unpacked that you'd like to maybe let services know about the functioning of the new law and what they can expect from it?
Yeah, we've seen this in the past with the introduction of other types of offences that I'd say are similar but have some of the same contextual elements to it. We're in the beginning phase of it. From a Queensland Police Service approach, we're just trying to monitor the volume and some basic statistics on what's occurring in the offence realm, particularly looking at things like other offences that have been recorded and the occurrence associated with the criminal offence of coercive control, as well as into the charging process. This is going to be a longitudinal game as far as research or pulling any viable information from it, because for your viewers, the offence in itself is indictable, and that might mean too much to many people, but maybe mentioning that it's a 14-year offence in the shortest and most uneloquent way of explaining the criminal prosecution process, it's something that's got to go up to a higher court. So it's not something that's going to be heard on evidence in a magistrate's court. Plea of guilty, yes, but if the matter gets tested by means of a brief of evidence put together, all the witnesses, all the evidence is being displayed to the court, that's not going to happen for a long time, which means that the ultimate test of how the offence is being worked and looked at through the scrutiny of the criminal justice system, we're not going to have that answer for a bit of time to come. We're likely to find in the first 6 to 12 months, provided the holistic investigation is there and the sufficiency of evidence is being met, that we're likely to get a few pleas of guilty in the first context, where it's a good investigation, the evidence is clear, and the perpetrator hasn't got much of a choice other than to plead guilty. We'll see some sentencing outcomes, but the testing of the legislation by means of its intent, yeah, it's going to be some time before we fully have the answers to that.
So given the time that it will take for the cases to work their way through the courts and for there actually to be a test case to actually test the strength or the validity of the legislation, are there plans already in place for evaluations to occur, for a review to happen down the track? Is there a timeline for those sort of, review and evaluation activities?
Yeah, not a timeline to review the legislation. That'll happen through another department through the administrative arrangements. But for us, we're trying to monitor every occurrence and get preliminary information just to follow, at this stage, follow along through any prosecution that's commenced. So none have reached the penultimate outcome of a sentence as yet that I'm aware of. And I'm not even aware that any have actually reached a committal phase, which might not mean much to viewers again. But it's the phase in the magistrates' court where they see some of the evidence to make sure it's sufficient to go up into the higher court, the district court. So they haven't even hit that stage. So we can, when we do get a few sentences out, we can case study those to see what the investigation looked like, if we can identify, and it's a manual process, where was the tipping point and the sufficiency of evidence that they suggested that, yep, they're going to plead to that they weren't going to contest it, as opposed to those that go up into the higher court, and they'll be managed through the Office of the Director of Public Prosecutions as to the standard there that they move through to an indictment, to either a trial or a plea in the higher court. And that's why we're supportive of agencies being involved, the peak industry body, Department of Families, coordinating our efforts so that we're all operating under the same government framework, which was, oddly enough, a number of the recommendations that came out of the Women's Safety Justice Task Force cooperate and integrate our services so that we're getting best effect.
That sounds like a really good place to leave this conversation, cooperating and integrating with effect. Thank you, Michael, for your time today. Thank you for answering all my questions and all the context and all the education you gave around the different ways that police will approach the occurrences and the approaches to charging and the timelines that we're talking about. I really appreciate your time today. Thank you.
Not a problem. Appreciate it.